Hi guys, my name is Ryan Casey, and I'm here to do a presentation for you for business law. We are going to be looking at a hypothetical situation between Rainforest Cafe, a subsidiary company, and its parent company, Laundries LLC, which is a conglomerate which acquires and owns various restaurants and entertainment chains, etc. Now, specifically, we're going to be looking at ownership of IP and how complex that can get between two companies that either own parts of each other or own wholly parts of each other. In this specific example, we're going to be looking at parts. To set that up, though, we're going to look at the situation itself. So let's go ahead and take a look at that. The cafe is in danger. Despite constant market setbacks, Rainforest Cafe Ltd is still operating healthily. Now, for those who don't know, Rainforest Cafe actually did experience a little bit of some market trouble over the past couple of years, especially with the pandemic. It forced them to close their doors, operate less wholly, and over time, it forced them to close locations they otherwise wouldn't have had to close, and it put them in a tight spot. Luckily, Laundries LLC, the company that owns partially Rainforest Cafe, was able to set them up with a lot of recruitment campaigns, a lot of investment, and able to keep them afloat. As a brand, they are still doing pretty okay despite having closed a lot of their major locations. However, they've kind of locked themselves into a bit of a legal battle, and here's how. A representative of Laundries trying to generate hype for the brand used our intellectual and trademarked property for a promotional event for sale. This cost the company thousands in post-production costs that they didn't see back. Specifically, the fact that what they were guaranteed to sell in merchandise only in their store was sold at an event and was given directly into the pocket of Laundries. This is also a violation of our trademark registration agreement established in 2002. We had set up partially an agreement wherein Laundries could use Rainforest Cafe to promote, advertise, and generate sales for Rainforest Ltd. However, they were not able to buy, sell, or manufacture any of the merchandise that came from any of our IPs, including our mascots, which is where we get into an issue down here. Now, the product that was sold was the Red Eye Squishable Tree Friend plush, a new development in huggable technology that takes the appearance of Cha Cha the Frog, our main mascot. It is one of several mascots that were trademarked on March 8th of 1998 alongside the Wild Bunch, which is our line of mascots and our main IP. It is the animals that you see in the animatronics that were designed by hand from the company, that's put on all of the menus, etc. Now, both companies technically own a Wild Bunch trademark. However, we own the trademark that gives us specifically the sole right to sell, manufacture, and distribute the product as a company. Now, how do we do that? Well, Laundries obviously forgot or misused our license agreement according to what is called California's TM100, wherein we have sole ownership of the Wild Bunch production. However, going to court to settle this will be more expensive than recouping our costs. So we need to draft a concurrent trademark registration agreement which tells the Laundries and the court what our rights to the shared property are. Now, California's Trademark 100 is a legal document about 5 pages long which details how, who, where, and when a product is sold. It basically gives out to a California Secretary of State every part of information they need to determine who owns a trademark. Specifically for us, I redrafted the Secretary of State TM100 for the current information of Rainforest Cafe Ltd., specifically towards its plush animals and printed materials. Now, we're going to go over this form because this actually does play in part to our CTA. Without this TM100, we have no legal standing to make a CTA because we technically don't own the registration number, which is filed inside of this document. Specifically, we know that the name of the owner is John L. Beard. Our business address is 5015 Westheimer Road over in Houston, Texas, now that he is closer to the Laundries. The corporation is still filed under Rainforest Cafe Limited, and our name and design mark and identification of goods and services both serve a similar but different purpose. The name or design mark gives us all of the list-like attributes that could be applied or described to a product to identify that it is ours, that is the product that we are attempting to trademark. Identification of goods and services, however, shows exactly which products we are labeling as ours in the trademark. So for instance, name or design mark notes that Rainforest Cafe, the Wild Bunch, etc., that is a group of items that are identified by name brand. But identification of goods and services, that shows what exactly we have as property that can be listed as ours under that same trademark. 0116 in the classification codes of Part 9B is printed materials for children. 005 and 022 are children's toys and products. We even have stuff for furniture and for printed material that's used for culinary goods, etc., all of which have Cha-Cha and the full mascot brand. Our U.S. patent and trademark information here is just the bare essentials. We have our filing date, which was the 9th, the day after we had already applied for the service. Serial file number, which is what we used as a business transaction to give a trademark between businesses. This is what the laundries also own. They have that 759A2249 number. The application, of course, has been registered and renewed multiple times over. The business itself is alive and thriving, so there's no chance that it's going to be going away anytime soon. However, we also have another number, and that's called a TR number, or a trade rights number. And that identifies that John L. Beard in this TM100 has full and sole ownership of the Rainforest Cafe Ltd. And thus has full ownership of the Rainforest Cafe, the Wild Bunch, etc. He's agreed to share this trademark. However, the origination is from this TM100 document. And as you can see from Part 11, we have all the check marks as marking exactly what is and is not applicable for our trademark. Everything's here. So the Wild Bunch is completely in our hands. For laundries to use this trademark in the way for sale is a violation of this document and a violation of our prior contractual agreement. So what are we going to do if we're going to avoid going to court? Well, we're going to draft a concurrent trademark agreement. And that agreement helps us define uses of a similar trademark or for corporations who share the same trademark and use it for different reasons. A very clear example would be a CTA can define the difference between how a company that owns Teenage Mutant Ninja Turtles can use its IP in a much more vast way versus how a computer company can use the same IP to make a video game and what that company owes the other company to draft and make that game. Now, definitions of legal partners, what the publisher owns and what the owner owns, are so important at the beginning of this document. We're looking at the agreement between Rainforest Cafe Ltd. owner and Laundries LLC, the publisher. Even though Laundries has purchased Rainforest Cafe Ltd. in part as a conglomerate, it does not wholly own all of the IP of Rainforest Cafe. We still, by technicality with that TM100, own the intellectual property of the Wild Bunch. So therefore, we have to draft two different defining paragraphs which determine what the publisher owns and what the owner owns. If you'll notice in owner's mark, there's that number 2643642 number. That's our trademark application number. That is our registration number that we have that is different from the Laundries LLC. They cannot own the IP in the same way that we do. This establishes exactly where the problem was with them using our IP without exactly situating fault on any one party. It simply determines who has what and where. Below, of course, is the clause that shows that this is in order to avoid confusion between marks, their concurrent rights, between consumers, and etc. So therefore, in consideration, we have each of the agreements. These line by line, break by break, determine exactly how and where a group can use our IP. Use by publisher and use by owner establish the basic agreement of the two parties. Cooperation of the parties and concurrent registrations force the court to both allow the court to make the agreement transparent to the public and without deception, and unite the registration of the trademark jointly. So we are determining that what is ours, what is yours is yours. However, how you can use what's yours is also a big deal. You'll notice up here in the highlighted section, limited use for corporate recruitment and advertising without sale of product. That shows that no longer can laundries use our product that we make, that we manufacture, that we sell in order to make profit for themselves. They have to send that profit to us. We use these to define the limits of our IP to stop Laundries LLC from using our product for anything other than promotional and recruitment activities without sale. We then go to release and abandonment. That clause allows us to avoid litigation from Laundries LLC and vice versa. They can't sue us, we can't sue them, specifically towards this agreement. It binds them as well to the list of agreements laid out in the document, because as you'll see in the release, this agreement is not an admission by either party of unlawful conduct, but at the same time, all claims arising from the other's use of alleged misuse are not effective to the date of this agreement. They are gone. So if also they abandon the IP at any time, we can reclaim it as our mark. We can take that trademark. Licenses and assignment denote that both parties have rights to the IP, while the governing law establishes that California's Model State Trademark Law, California Business and Professions Code, sections 14200 et sec, all form the basis of the agreement. So we are determining that TM100 is in fact the law of the land, that it does determine that we are the owner. We are choosing California because that's where we filed. Likewise, we are establishing that despite that, we will share this IP, but only if they follow through with our agreements. Integration and severability both jointly describe how enforceable the document is, with integration denoting that no agreement can revoke its power, while severability gives the owner the ability to avoid contractual litigation outside the agreement. Amendments allow both parties to redraft the agreement rather than dispose of it. Both parties must agree to the terms herein. They are bound by them unless the agreement is proved to be unenforceable or amended by both parties. Payment by publisher is the good stuff. We lost a bunch of money from having to have that product sold and the profit not coming back in our hands. We essentially have Laundries LLC pay the full fee for using our IP plus the price of licensing while agreeing to our terms. This helps us settle the dispute without going to court, establishes that we own the IP, and sets the payment window for a timely manner. We essentially sell them the license while ensuring our IP is used correctly. We thus agree in a covenant not to oppose, to not be a false giver, and to not revoke the license should they choose to register it elsewhere, as long as the publisher follows the agreement. In conclusion, Rainforest Cafe is able to establish clear rules for its IP by creating an agreement with its relative company and establishing its ownership of the trademark, setting forth terms and conditions while avoiding nasty litigation. Concurrent trademark agreements can in fact help a company protect its property, especially when conflicting narratives about who owns what arise. Thank you.